Hi, I'm Johnny Engineer, and this is my federal court statement of claim challenging the COVID mitigation restrictions because they compared Apple to Orange to hype the threat by a factor of 100. So see the link below if you want to read the statement of claim, and I'm going to explain how to get your own and join me in the fight to stop the lockdowns. So, I've been inviting people around the net to join me in this protest against COVID lockdowns. Any conditions, because there was some fraud that happened and I caught them. So I'm going to read you my blurb to everybody out there and let you decide for yourself if you want to join me in this fight. So this link, you can see below, is my video on my statement of claim, you can see that below, filed in Federal Court of Canada on January 19th, 2021, asking to prohibit COVID mitigation restrictions or exempt me from them on grounds the C19 CFR Apple was compared to the flu's IFR Orange to exaggerate the COVID threat by 100-fold. It should help that federal tax court has accredited me an expert witness in the mathematics of gambling. So, this other link now are the instructions to fill out the COVID challenge template, statement of claim for yourself. You save it as a PDF. Then you go to the e-filing instructions for e-filing with the federal court registry. So you can read my statement of claim to see if you want to join me in the protest. It costs $2 to file in Federal Court of Canada against the Queen. Isn't that great? So the statement of claim link is there. It's the statement of claim template anybody can use. You stick in your name, address, phone number, email, sign it, and then save it as a PDF and you're going. Now my templates have been used in self-defense or self-offense hundreds of times before. So I have a smartestman.ca/kits is my page listing all the court templates I've engineered over the years. In the 1980s, I offered those being foreclosed under the 22% interest rates to self-defend with templates of arguments they could sign and file to stall their eviction. The Toronto Woodhouse case was stalled 33 months while they fought rent-free. After 2000, I used templates for people to self-defend criminal cannabis charges. I appeal all my cases to the Supreme Court, learned those ropes too, and the judges know it. MedPod cases are still ongoing. In 2003, my appeal forced the Crown to stay 4,000 marijuana charges, and there's a link to that headline. Now, I learned the federal court ropes by suing Elections Canada every time I was a candidate in one of my 101 Guinness record elections contested over 42 years. And a media station didn't give me an equitable share of the free debate time, like the law said they should. I sued them umpteen times. Lots of election case law with my name on it. Ropes learned well, federal court. Now, permits back. After 18,000 MedPod patients had had their Health Canada grow permits cut off by a judge 6 years ago based on the date of the permit, all grow permits extended. But only the second half of the year kept their possession permits. First half lost their permits to possess what they had a license to grow. So with the media focusing on the 18,000 joyous survivors and ignoring the 18,000 devastated losers, I got almost 400 patients to file a $2 statement of claim trying to get their exemptions back from Health Canada based on the fact that their doctors had prescribed it, and who cares what a judge thinks about dates. It swamped the Crown and the registry. At trial, the Crown said it was a remarkable, extraordinary, unprecedented to have televised hearings in 10 provinces in 12 cities. A judge struck down the exemption regime in another case and dismissed our beefs as handled, or we could complain against the new regime again. No costs. From May 8th, 2014 news, MedPod activist creates legal kit used by more than 200 people. And then there was another article, federal court flooded with lawsuits for right to grow pot, and finally federal court flooded with medical pot cases. That was CTV News, CBC News, and Global News. Now, damages by permit for permit processing delays. 2 years later, a second group of med potters used templates to claim damages due to delay by Health Canada in processing MedPod permits. You could fax your prescription to a licensed producer and get your pot by courier the next day. But to self-grow, you had to send it to Health Canada, who took up to 11 months to process the paperwork while you paid rent on your grow site. One fellow had a 6-month medical document and it expired before Health Canada opened his application. I got another almost 400 patients to file online for expedition of the processing or an interim exemption. In that instance, Judge Brown named one lead plaintiff, and what happened to him was persuasive for the others. Except only one plaintiff would pay any costs, and they're peanuts for self-defending sick people. So, there was an article August 17th in iPolitics, hundreds of court claims allege delays in permits to grow medical pot. Igor Majenko's damages claim for delayed processing or grow permit is on reserve decision at the Federal Court of Appeal for the past 2 months, since November. So, strike 150-gram possession cap for high dosers. The next template. One other group of self-plaintiff actions are still ongoing. In 2014, a judge changed the possession limit for marijuana from a 30-day supply, like all drugs, to a 30-day supply with a 150-gram limit. In BC, some daily high dosers in Garber, 60, 100, and 166 grams per day, asked for exemption from the 150-gram cap, and the judge granted them a 10-day carry limit. My next template had self-plaintiffs fill out the kit and statement of claim to strike the cap and restore the 30-day limit, while asking for an interim exemption for a 10-day carry as the BC Garbers, pending trial of the cap strike. Crown moved to strike for no cause of action. Judge Brown dismissed it and let the actions in, and granted the lead plaintiff the same 10-day carry as the BC Garber plaintiffs. The Court of Appeal overturned Brown's decision. The battle continues. July 3rd article, patient who uses 100 grams of pot per day, granted right to possess a kilogram at a time, 10-day supply, and that was overturned. So that's twice before we've swamped the courts in protest with almost 400 self-plaintiffs out of under 20,000 aggrieved patients. Now, how many have been aggrieved by COVID restrictions? If 400 out of 18,000 aggrieved plaintiffs filing self-offense claims for damages freaked out the Crown and Registry twice, imagine if 4,000 or 40,000 out of the millions aggrieved by COVID restrictions seek damages too. Sure, protesters can violate restrictions and get arrested, or you can ask a judge in a Zoom call for an exemption from these restrictions on this minor cold, even if made in a biolab. Now, can you think of a better way to get the message heard with no danger of criminal charges to yourself than to present proof it's a hoax to a judge with power to fix things? Now, I've watched people complain about the restrictions, especially in Quebec where my brother lives and who filed today when I wrote this. There are actions in Quebec courts but against the restriction, like the curfew. So once I've got a team of people to shake up the Crown and Registry with another bigger onslaught of claims, then we can next file motions for hearings to get personal interim exemptions while we fight, just like the MedPod applicants did. In our 150-gram possession in public cap challenge, the Crown moved to strike the claims, but the judge let him in and granted lead plaintiff 10-day supply. So we'll ask here too. You can ask for interim exemptions for a piece of what you want totally, which is to prohibit all conditions. So this scamdemic has to be put to rest, and good statistics are available and should be all that are needed to squelch it. Add your plaints of how restrictions have made you suffer. At the end of the statement of claim, there's a place for you to add your complaints and your damages and your losses, and what damages should compensate for it. This could turn big because so many have used the federal court templates before and can now teach others how to do it. People who need help send me their name, address, phone number, and a JPEG of their signature, and I stick it in the blank form, add their signature, save as PDF, and go to the registry site. In 5 minutes, I got them filed. You can do that too for your friends once you've learned to do it. So, Smartestman.ca, C19INS for instructions, .pdf for instructions on how to prepare the claim and how to file online. Now, people have said these instructions are really easy to follow. Come on, 800 followed them in the last few years, most by themselves. So give it a try. Anyone daunted by the process can send me their information and I'll do it for you. My email's johnturmel@yahoo.com. Now, I've done it so often before it only takes me 10 minutes. So you just take the call for the $2 credit card to pay your filing fee, and you end up with a nice gold star statement of claim like I do. Now, I'm going to go to the instructions and very quickly read them, how they work, okay? Here we go. So, now at the top, if you go to C19INS, oh, that's the wrong one. There it is. C19INS. I have a page called Kits, smartestman.ca/kits, where all of my templates over the years are listed. But this is a statement of claim against COVID restrictions. So I give my statement of claim, C19SC, statement of claim, JCT, my initials, .pdf, so you can go read it. And it's based on them comparing C19 CFR to flu's 100 times too small IFR to exaggerate the COVID threat by 100-fold. Got it? That 100 is magic. They exaggerated the threat by 100 with an Apple Orange comparison that's easy for me to prove. I've launched court battles with templates many times. In the 1980s, I had stiff the bank kits, templates to oppose cannabis criminal charges, and recently in federal court, I got the listings of those stories I read about earlier. And then all of them. So to join me in opposing COVID restrictions, the template to prepare your own statement of claim is smartestman.ca/C19SC.pdf, statement of claim. And I also have a docs file, DOCX. If you can't change a PDF, you can always change your Word, and then you can save it as a PDF and insert your signature. So replace the blanks with your own data. In the last paragraph, number 130, you can add in point 5 and 6, in Part D, the pains and losses you have personally suffered due to COVID restrictions. Some basic rights violations everyone has suffered are listed originally, and you can add more. Now's your chance to get your stories on the record in case a judge wants to give you some money for your pain and losses caused by a government tricked by an Apple Orange comparison. Can you imagine any greater incompetence than being tricked by a 100-fold Apple Orange comparison? Exactly 100. It's beautiful. So go read it in my statement of claim. With the PDF ready, you go to smartestman.ca/efiling.pdf, and those are the instructions you need to go and file it at the registry, every step of the way. Now, I've got a video there on how to file, and I'm telling you about motions that are coming up, okay? And that was also in the other article I just mentioned. So basically, we're ready to launch another massive protest in the federal court and freak out the Crown and the registry, and who knows, probably have another hearing in all 10 provinces, in 12 different courthouses, maybe a couple more, there aren't that many federal ones, and simply blow their socks off by proving that these clowns fell for a 100-fold exaggeration by comparing Apple CFR to Orange IFR. And of all the scientists and chemists and medical people and doctors in the world, I am the only person with a science degree to have noticed that we got Apple Oranged. Isn't that cute? Don't I feel proud? The only person in the world. Another worldwide claim. Back in the 80s, the whole world was led to believe that raising interest rates for producers would lower the prices that you had to pay. So I did an analysis and I said, whoa, raising producers' costs is going to raise their prices, not lower them. So the whole world were suckered into believing raising costs would lower prices, except me. Isn't that neat? And since then, I've been the only person in the world who has proven that inflation is not more money chasing the collateral. It's the same money chasing left's collateral after they foreclosed it. Check my Shift A, Shift B analysis. But anyway, it's in there at my statement of claim. So there it is. I've given in my statement of claim a lead to my inverts which explains the missing dimension in math, okay, that people weren't taught. Everybody knows how many nickels in $1.20, and how many quarters in $1.04, or how many 4 pence in $1.25, or how many 20 pence in $1.05. So you have these numbers you know inside out from your money, but you don't know 6, 7, 8, and 9, what the inverts are to get to 100. 9 times 11, and 12 times 8, and 14 times 7, and 17 times 6. You were never taught those. And without those, you can't do fractions and decimals. You can't convert. So I have a lesson called Inverts, which teaches you how to do that. Okay? I think it's kind of amazing. It's never been taught before. But anyway, so there is my claim that this is a fraud, this is a hoax. Well, you know, it's some kind of a flu, but it's a mini flu. It's a 1/3 flu, you know. And the major grounds, again, I'm going to say, are the 100-fold, and there's no asymptomatic spread, okay? It's never been shown. All the statistics say 0. 10 million people tested in Wuhan, 0 asymptomatic spread. 0. Got that? So it's been mentioned over. They never found any, but they keep saying, we might, so keep wearing a mask. Got that? The reason for masks is that you can get it without sniffles, seeing on the other guy. And it's not true. You don't have to stay away from him if he's not sniffling. So if you got sniffles, don't go visit grandma, just like the flu. But if you don't have sniffles, you're okay, is what we found. So that's another big lie in the scam. And the third one was in Canada. By 2015, there were 10,947 deaths, 10,781 of which were in long-term care, which means that only 166 weren't. And they probably had diabetes and obesity and cancer and name it. So almost nobody in Canada who's healthy died. Nobody. So 17 if it's 10% of the 166. But anyway, there we go. The numbers have been fudged. It's a complete exaggerated hoax. And we can put a rest to it if enough people join me in spending the $2 to get their trophy that they objected to lockdown on the basis of fraudulent statistics.